Swayam Prabha. Digital India. Educated India.
The title of the course is Land Laws, and myself Dr. Kavita, Assistant Professor, Faculty of Law, University of Delhi. And so welcome to the session on this land laws. In today's session, I am going to talk about the historical development and evolution of land laws, what basically the land law is, the importance of land rights in India, overview of land rights, the significance of land ownership and access. So after this session, you will be able to understand what is land law and about the legal land rights and the significance of land ownership and how to access it. So first of all, I will start with the definition of land law. What is land? Basically, as the name implies, land law is focused on the rules and governance of land, including ownership, land use, boundaries and access. It is the form of law that usually you can say that deals with the right to use land, alienate or exclude others from the land. So in many jurisdictions, these kinds of property may be termed as real estate or real property as distinct from personal property. So land use agreements, including renting, are an important intersection of property law and contract law. Encumbrance on the right of another land, you can say that, such as an easement, it may constitute the right of another. So this land law, it basically impacts upon many facets of our day-to-day living. It basically determines the difference between what is land, what is property, and how to access it, the right to land as a tenant, and how one can own the land. So these are the perspectives with respect to this land. So as I must say, this land and property are a related terms, but they have slightly difference between these two. Like land, you can say that it means surface of the earth. It is a subset of the property. But what is property? Property, you can say that it may be movable, it may be immovable, it may be tangible, it may be intangible, because every man have a property in the eyes of law. If a layman says that he have no property, it is wrong, because if a person have a right to enjoy the house as a tenant, that is also a property. So property, it may be building, it may be surface of the earth, it includes benefits arising out of land, it may be corporeal, it may be incorporeal, which can be touched, which can't be touched. So property has a very vast meaning, because according to Selman, everyone have a property in the eyes of law. As according to the Food and Agricultural Organization of the United Nations 2002, land rights broadly refers to right to use, control and transfer a parcel of land. They include rights to occupy, enjoy and use land and resources, restrict or exclude others from land, transfer, sale, purchase, grant or loan, inherit and bequeath, develop or improve, rent or sublet, and benefit from improved land values or rental income. Now I will talk about basically the various types of rights, land rights in India, because land rights are of several types, which are a part of a wider bundle of rights that exist due to inheritance, operation of law and so on, and they include the following. First one is leasehold rights, which relates to a tenant's or a lessee's exclusive interest and right to possess, hold and use property under the terms of a lease agreement established between the landlord and the tenant or the lessor who owns the property for a certain period. That is known as leasehold rights. Talk about freehold rights here. In simple terms, it refers to the absolute title, right and interest with respect to the concerned land, and these rights indicate that the property owner enjoys ownership rights over the whole property rather than any other entity. So therefore, the owner of such an estate has entire ownership in perpetuity. The freehold property owner can use the land parcel for any lawful purpose subject to local norms and laws. Third one is development rights. It basically allows the real estate uh, developers to make changes to their property subject to the limitations imposed by local laws or the state. So the owners of the property here in development rights have the right to make improvements following local or state laws. The transferable development right is a sort of development right that can recompense owners by allowing them to use the development potential of their own land parcel from another land parcel. So this transferable development rights are recognized by some states and are controlled by building codes and municipal legislation. Another method of obtaining property here is to engage in a joint development agreement with the title holders of the relevant land parcels for the joint development of a real estate project. So contractual rights are the same. Next one is charge on property or mortgage rights. There is a difference between the mortgage and charge, because mortgage is a transfer of property but charge is not. So, but basically this charge or mortgage, it creates interest on behalf of the mortgagee or lender in an immovable property in question to obtain the following regarding current or future debt, fulfillment of an engagement that may result in monetary liability. So in simple terms, mortgage is basically you can say that as a security the person mortgages his property to the mortgager, mortgages his property to the mortgagee. And in India, several forms of mortgagee rights can be created for immovable property. These rights include usufructuary mortgage. Basically, there are 6 kinds of mortgages: simple mortgage, English mortgage, anomalous mortgage, conditional mortgage. But in usufructuary, the possession is also given to the mortgagee. Mortgage by deposit of title deeds, there is no requirement of the process of registration because it is based on the deposit of title deeds only. So these kinds of mortgages play an important role in creating an interest on behalf of the mortgagee or a lender in an immovable property. But charge, you can say that the charge holder gives his property on charge just as a security. It is not creating any interest there. So there is a difference between this charge and mortgage. Then comes license rights. License rights here refers to a licenses, non-exclusive right to enter, occupy and use a property. The licensee doesn't get any interest there or easement in the land, and the rights mentioned are not inheritable or transferable as well. Then comes easement rights. Easement which can be exercised on the land of another person. So it are of the easement are of 2 key types here. We can say that first one is which is granted for the beneficial enjoyment of a specific parcel of land. जैसे हम dominant heritage, like dominant heritage is there. Easement granted for preventing the use of another parcel of land, whether it is her or not, whether that property, but he is granted for the use of another parcel of land, servant heritage. So right of passage, right of water, right of way, you can say it is an example of an easement right. So these are the examples of easementary rights. Next is subsurface rights. These are the rights to the ground underlying a parcel of property and any material discovered beneath it. Subsurface rights, it includes mineral rights. For example, minerals, subminerals, they are the example of subsurface rights. So these are the various kinds of rights rights of land in India. So leasehold rights, freehold rights, development rights. So these are the various types of rights. Next, I will talk about the historical development of land laws in India. The history of land law in India is a complex and fascinating one. The laws have evolved over the centuries to reflect the changing social, economic, and political realities of the country. Uh, Land has been a fundamental part of Indian society since ancient times, and it has always been seen as a valuable resource. Land laws have been developed to ensure fair and equitable access to land for all, as well as to regulate its use, transfer, and ownership. In ancient India, land was considered a community resource and was owned by the king or the village council. The king or the council would distribute land to the people for cultivation, and in return, they would pay taxes to the state. The right to use the land was not absolute at that time. It was subject to certain conditions, such as the payment of taxes, the maintenance of irrigation systems, and the performance of certain services for the state. During the medieval period, land ownership became more centralized. The Mughal emperors and other rulers granted land rights to their nobles and officials as a reward for their services. The landowners would collect revenue from the peasants uh, and pay a portion of it to the state. The landowners had the right to use the land, but they did not have absolute ownership, and the state retained ultimate control because they didn't give absolute right to the people. Talking about British India, the British East India Company established its rule in India in the 18th century. They introduced a new land revenue system that led to the commercialization of land ownership. The British introduced the concept of individual land ownership and created a system of land surveys and settlement, which was aimed at assessing the value of the land and the revenue that could be generated from it. The land revenue was fixed. It based on the assessment, and the landowners were required to pay it to the state. The Britishers also introduced various laws to regulate land ownership and transfer, like the Transfer of Property Act 1882, which regulated the transfer of immovable property, including land, the Registration Act of 1908, and it made it mandatory to register all land transactions, including sales, mortgages, with the government. After India gained independence in 1947, talking about here post-independence India, the government here introduced a series of land reforms, which basically aimed at redistributing land to the landless and the small farmers, which do not have the land. So these farmers and the landless people, they get land through the government. So the aim was to reduce inequality and promote social justice. So everyone have a land as per the government justice. So the first major land reform here was the abolition of intermediaries and Land Reforms Act of 1951, which abolished the zamindari system and granted ownership rights to the tenants who were tilling the land. The government at the same time also introduced tenancy reforms to protect the rights of tenants and to ensure that they were not exploited by the landlords. Because usually what happened, the landlords took the advantage of the tenants' financial position, they gained certain benefits. So the Land Ceiling Act of 1961 was introduced to limit the amount of land that an individual could own, and excess land was redistributed to the landless and small farmers. In the 1980s and 1990s, I am here talking about this time, the government introduced a series of amendments to the land laws, which aimed at liberalizing the land market, making it easier for the private companies to acquire land for industrial as well as for the infrastructure projects. The Land Acquisition Act of 1894, which was later on replaced by in 2013 by the Right to Fair Compensation and the Transparency in Land Acquisition, Rehabilitation and Resettlement Act, which made it mandatory to obtain the consent of the affected landowners and to provide them with fair compensation and rehabilitation measures. This was the historical background, you can say that, how the land laws was evolved. Now I will talk about the laws which governs land use in India. The legal framework for land ownership in India is a complex web of laws that govern land registration, transfer and stamp duty for transactions. The Constitution of India itself consists of three lists. The land was the subject of the state list. Till 1977, property right here was regarded as a fundamental right. However, after the 44th Amendment in the Constitution, this property right was no longer a fundamental right. It became constitutional right, which is to be protected under the authority of land ownership laws in India. So today, the right to land in India is protected and regulated by state laws. Different states have different land ownership laws in India to check and restore any illegal transfers in land. So, as an example, we have this Indian Registration Act of 1908, which is a federal law regulating document registration, including land transactions. So basically, it checks and restores if there is any illegal transfer. It must be mandatory registrable under this Registration Act. So this is an evidence with respect to the property documents, we can say that instruments. So this act, it mandates that certain documents, it must be registered to ensure the legality and enforceability of transaction, because it has the value in the eyes of law if once the document is registered. Because there are two types of, you can say, two modes of transfer of property. One is by delivery of possession and the other one is by this written instrument. So whenever there is a transfer by written instrument, registration is mandatory if the value of the land is above rupees 100. Then comes this Transfer of Property Act 1882. We have this law which governs the transfer of property in India, and it applies to all properties including land. The act set out the rules for property transfer through sale, mortgage, lease and gift. Because this Transfer of Property Act, it basically deals with the transfer of immovable property by living person. Basically, it deals with transfer inter vivos, transfer between two living persons. So this is a central law which governs the transfer of property by way of sale, mortgage, partition, lease, gift, settlement, because there is an involvement of two living persons there. That's why it excludes the transfer by operation of law, by court's order. However, with the exception of certain instances, the Act does not govern the transfer of property by operation of law, such as sale by the order of court, we have CPC, auction or forfeiture, as well as the transmission of title under other laws. As per section 5, where the transfer of property is defined in this, that it is an act by which a living person conveys property in present or in future to another living person. So it is an act, it is an activity or process. It is not transferred automatically, as in the case of inheritance, as in the case of a will, we can say that. So it is an activity, because without the act of the transfer, there will be no transfer of property. Living person conveys property, because here the expression conveys, this is very important, because conveyance here means creating new interest in favor of another person by creating new title or interest in the land. So conveyance is must. The expression conveys property. It basically governs the property in present or in future. The person can transfer the property. It does not govern property, because the property, it must be in existence at the date of transfer. So it governs only the time, basically, that it may be present, it may be done in future, but it only governs this thing. And himself also, this word is also added by the Amending Act of 1929. now a person can transfer a property to himself also by in some other capacity, not in individual capacity, like creating a trust and himself appointed as a trustee there. So, this is Transfer of Property Act 1882, which is basically governs the transfer of property, mainly immovable property. It mainly deals with the provisions of immovable property between two living persons. That's why it excludes by operation of law or by court's order. Then we have Indian Contract Act 1872. This act, it prescribes the law relating to contracts in India and is based on the principles of equity and common law. It is applicable to all the states of India. It determines the circumstances in which promises made by the parties to a contract shall be legally binding and the enforcement of these rights and liabilities, and it plays crucial role in cases of arbitration clauses, termination of contract, determining damages, etc. Because this contract act, it mainly deals with general principles like agreement. There is an agreement between two persons. The person must be competent to transfer. If somebody does any breach of contract, then one has a remedy to go before the court to go and ask for specific performance of contract. So for this purpose we have this Indian Contract Act. Next is Power of Attorney Act 1882. This Power of Attorney Act, it is an instrument by this word I mean to say legal document, whereby the grantor authorizes the grantee to do certain acts specified therein on behalf of the grantor, which when executed will be binding on the grantor as if the act done by him. So the rules regarding the same are governed by the said Power of Attorney Act 1882. So it is a legal document whereby the grantor, he authorizes the grantee to do certain acts on behalf of the grantor. So it legalizes, it basically governs that thing. So we have for this purpose this Power of Attorney Act. Then comes Indian Stamp Act 1899. At the time of execution of registering the documents, because there are three main essentials of transfer of property. First is execution, second is attestation, third is registration. So at the time of execution, certain applicable stamp duties has to be affixed on the documents in order to register the documents by paying the registration fees. The rate and value of the stamp duty payable on each document are detailed in the Stamp Act. So it must be according to that act. If I will say here like an immovable property, then that have a different value. Like if a property is above 100 rupees of value, then it must be registered. Then the person has to pay the stamp duty as per this Stamp Act. So for this purpose we have this act. Next is Registration Act 1908. Very important act for this land use or land rights. Under this act, as per section 17, documents transferring title to immovable property whose value exceeds rupees 100 are compulsorily required to be registered with the concerned sub-registrar of assurances in order for the transaction recorded therein to be recognized by law. So registration, registration is must, but not in all types of documents. Like if it is a will, there the registration is optional, it is not mandatory. But in case of gift, in case of sale, in case of mortgage, in case of lease, if it is above 100 rupees of value, then it must be registered. Only then it has the importance in the eyes of law that it is registered. So that's why here the failure to comply with the same would not create valid ownership rights in favor of the allottee. So one has to prove this thing that the formalities which prescribed under the Registration Act has been duly completed, and it has been duly completed once the sub-registrar has signed the document. The date and the time was mentioned there in the instrument. Usually when an encumbrance certificate for any property is requested, a search is conducted by the officials of the concerned sub-registrar's office to ascertain if the property in question has been subject to any transfer charge for the period for which encumbrance certificate is requested. Because encumbrance on the land of another, such as an easement, it may constitute the right of another person. So it is necessary there to make a search by the officials to ascertain if the property is really in which is in question has been subject to any transfer, if it is subject to any charge for the period for which that encumbrance certificate is required. So if the transaction is compulsorily required to be registered under the Act, and the document relating to such transaction has been registered, the encumbrance certificate will list all the registered transactions or charges created on the property for the period for which the certificate is requested. Lease deed which is executed for a period of more than 11 months has to be compulsorily registered with the sub-registrar of assurances. Rental agreement has to be compulsorily registered with the sub-registrar of assurances. So all the deeds have to be registered with the sub-registrar as per section 17 of the Registration Act, and it has to be done within 4 months from the date of execution of the document. Only then the document has some value in the eyes of law. Otherwise, if like in future some dispute is will arise between the parties, then one cannot ask for the relief before the court if the document is not registered, if it is of value of above rupees 100, because it is only happened that if it is registered, then the person can go before the court and ask for the remedy, and then he may be entitled to get the possession of the property. After 4 months, the period will be there to register the document by paying the penalty as imposed by the concerned sub-registrar of assurances, because the time period is mentioned here that within 4 months of the execution it must be registered. So if any failure on that on the part of the person, then there will be a provision for penalty as per this Registration Act, which is imposed by the concerned sub-registrar of assurances. And the consequence of non-registration is, as I had already said, that such document would not be regarded as affecting the property or transaction in question, and it would not be received as evidence in a court of law in the event of a dispute. Further, registration provides the following protection to the parties. A registered deed is a conclusive proof that the parties have mutually agreed to all the terms and conditions entered therein, and in the event of a dispute, the terms of the registered lease deed will prevail and will be enforced. And also, a registered deed will secure the rights of the parties from any unauthorized eviction by the third parties. Lack or deficit of stamping can result in impounding of the document when presented before a public authority, because as per the Indian Stamp Act also, the immovable property, for the transfer of immovable property, some stamp duty is required under the Indian Stamp Act, which must be followed by the person whenever there is a transfer of immovable property. But in case of movable, there is no such like mandatory provision. So the consequence of this non-registration, as I had already said, that it would not be regarded as an evidence in the eyes of law in the contract. So in future, if any dispute arises, then the party cannot take the benefit of this one if it is not registered. So it must be registered, compulsorily registrable, only then the person can take the benefit. Now I will talk about the laws which governs land acquisition. Land acquisition here is the power of the union or a state government in India to take private land for public use and to compensate the original owners and the other persons affected due to such acquisition. So the first land acquisition legislation in India, it was enacted by the British government in 1824. It enabled the British government to obtain at a fair valuation of land or other immovable property required for developmental works such as building of roads, canals and other public purposes. The Land Acquisition Act of 1894, basically it was the first enactment which was done by the British government in 1824 until 2013. The Land Acquisition Act of 1894, it governed the land acquisition in India. The older law did not clearly define the public purpose or fair compensation. So, after a number of attempts, the United Province Alliance government was able to replace the 1894 Act with right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Talking about the evolution of the Land Acquisition Act of 1894. This was introduced, as I had already told, that it was enacted by the British government in 1824, and this act was made enforceable in the provinces which were in control of Fort Williams. Soon after, with the Building Act 18 in 1839, the acquisition of land started in Bombay also. In 1852, after modifying first 7 provisions of the Bengal Regulation 1 of 1824, a new Madras Act 20 of 1852 was passed then. So, in all the presidencies at that time, the rationale for the acquisition of land was to acquire for public welfare purposes, which include widening of roads, building canals. So, I would like to draw attention of the readers to the fact that every act had the rationale to acquire property for public welfare purposes. After 1850, when the railways were introduced in India, acquiring land for purposes of building railways was added to the public welfare clause. The enactment of these acts here was to legitimize the act of land acquisition by the British for public welfare purposes. But in the year 1857, this Act 6 was enacted, which abolished all the previous existing acts on the land acquisition introduced till then. The East India Company wanted to improve the process, and also for the first time one can find the mention of the word compensation under the Act. An agreement was to be made which empowered collector to determine compensation under the same. And in case if there was no such agreement, the dispute was taken to arbitration. Because for land disputes, we have this remedy, the commercial types of disputes. We have this ADR, we have arbitration, mediation. So we know that on paper, every new advancement from the past, it looks lucrative. But when it comes to practically and ground reality, various factors are those advancements. So similarly, it was found that the process of arbitration was not satisfactory. In some cases, the arbitrators were found to be incompetent and corrupt, because sometimes what happened, the arbitrators were appointed by the parties itself. And if the arbitrator is, suppose he is partially give the award, pass the award, and he knows one of the party very well, so in that case, he may be found to be incompetent. So in 1870, a new Act 10th was enacted, which for the very first time mentioned a reference to civil court in case the collector fails to determine compensation according the agreement made between the parties. So later, on a separate act which was dubbed as an act of compensation, passed in 1885, namely Mines Act, dealt with grant of compensation to miners. So there were some problems in this Act of 1870, but I must say this Land Acquisition Act 1894, it stands as a cornerstone of India's legal landscape. It's shaping the nation's approach to acquiring land for public and private purposes. Enacted during the British colonial era, this legislation, it established the framework for land acquisition, providing the government and the private companies with the legal authority to procure land for infrastructure, industrial and developmental projects. But however, as there were some problems and subsequently it was repealed, and finally the Land Acquisition Act of 1894 was brought into picture. So there are certain drawbacks also of this Land Acquisition Act of 1894. Regarding this, the first one is like there is no provision for rehabilitation and resettlement of persons displaced due to the acquisition of land. This generates a lot of discontentment amongst the people. This was the reason why this was repealed and the new act was enacted in 2013. Second is low rates of compensation. The compensation which is paid, which was paid under the act is at prevailing circle rates in the area, which are not even remotely indicative of the actual rates. As a result, the government pays at their own market rate, which is nowhere near to the actual prevailing market rates. The government could acquire any land in the name of public purposes, and the term public purposes was so ambiguous that it finally rested in the hands of executive to have a say on what public purposes is. So sometimes the land was just acquired and it was sold to real estate developers for cheap price. So there was no real appeal mechanism against to stop the acquisition process. So that's why the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013, it replaced the archaic Land Acquisition Act 1894. This was the reason. So India's land acquisition was undertaken under antiquated Colonial Land Acquisition Act, which had led to increased distress, conflict over eviction of landowners and landless labor from their land without proper compensation or rehabilitation. So this led to enactment of this Act 2013, the Land Acquisition, Rehabilitation and Resettlement Act. And the objectives of the Land Acquisition Act, I am here to talk about the purpose, the goal of this Land Acquisition Act 2013, which is basically here to define and direct a land acquisition process that involves consultation with local self-government and the Gram Sabha, and is transparent as well, educational and participatory. This land acquisition process goal is the development of vital infrastructure and urbanization, both of which are required for public purposes. So, over a time, when the Land Acquisition Act of 1894 came under scrutiny for its perceived shortcomings, practically in terms of fair compensation and rehabilitation, we have this act with this purpose, with this goal to define and to give transparency regarding the process which involves consultation with the self-government. And the second objective is here to guarantee that the landowners whose property is being acquired receive equitable and fair compensation while taking into account all the economic and social factors. Likewise, to guarantee appropriate procedures and rules for the same. Aside from the landowners, other families that depend on the property either directly or indirectly also suffer when it is bought. The rehabilitation and resettlement of the affected landowners and their families is the third primary objective, which was not included in the previous Land Acquisition Act. So this act, it basically aimed to address the lacuna of the Land Acquisition Act 1894 by providing for higher compensation, better rehabilitation and resettlement measures, and greater transparency in the land acquisition process. This act, it adopts a human, participative, informed and transparent process for land acquisition, for industrialization, development of essential infrastructural facilities, and urbanization with the least disturbance to the owners of the land and other affected families. As per Section 2 of this Act, which provides for the application of the provisions of the Act to various types of land acquisition. It classifies here the acquisition of land into three categories. First one is appropriate government acquire land for its own use for public purposes. Second one is appropriate government which acquire land for the projects, public projects for private companies, for the purchases by private companies through private negotiations, because negotiation also plays an important role here in land laws, because after in negotiation between the two parties they agree on the same thing, because the win-win situation is there, because there is a benefit to both the parties. So according to Section 3ZA of the Act, public purpose here means the activities specified under Section 2 subsection 1, which includes the following agenda. First one is for strategic purposes, which is relating to naval, air force, military, armed forces of the Union, including paramilitary forces or any work vital to national security or defense of India or state policy, safety of the people, for infrastructure projects, agriculture, industry, educational purposes, sports, tourism, transportation, and any other infrastructural facility. We have relief development, planned housing, planned development, housing for displaced persons. So these are the various purposes we say, that is the scheme of this Rehabilitation and Resettlement Act as per Section 16. Also the administrator, according to Section 16, he must prepare the rehabilitation and resettlement scheme. In accordance with this section, the administrator here is responsible for conducting a survey and then doing a census of the affected families, following the issuance of the preliminary notification by the collector. So as per this provision, there is a person who is the administrator who is responsible for conducting the survey and then issue the certificate notification issued by the collector, details on the lands and other immovable property each impacted household is buying, livelihoods, loss for those who are landless and who depend heavily on the lands being acquired. List of public utilities, this is also one of the scheme here, government structures, amenities and infrastructure that are impacted or are anticipated to be impacted, whose relocation of impacted families is concerned here. Information on any resources that are obtained as common property. So these are the scheme for rehabilitation and resettlement as per the provision of Section 16. Now I would like to conclude with this, that the land rights in India are not specified in a single legislation, as I have discussed in my lecture also, that we have certain laws which governs here the land rights. We have certain laws, Transfer of Property Act, we have Indian Registration Act, we have Stamp Act. So they derive from a combination of various legal frameworks and regulations. So land rights here is important, because the right to land as a tenant who may have accessed the land, what are our rights, the people generally know from these legislation. So these diverse legislations, it collectively shape and govern land ownership, tenure and usage rights within a given jurisdiction. Because in many jurisdictions, it may be defined as, I had already talked about that, real estate property, real estate as distinct from personal property. So some of the key laws that regulate land rights in India include the Land Acquisition Act 2013. This legislation, it outlines the process for the acquisition of land by the government for public purposes. So the main scheme, the main objective, the main purpose of this Land Acquisition Act 2013 here is to address the to provide for higher compensation, better rehabilitation and resettlement measures, greater transparency in the land acquisition process. For that's why this act was enacted in 2013. We have Transfer of Property Act 1882, as I had already discussed. This act governs the transfer of property, including land, through sale, gift, lease or mortgage. Because here, this Transfer of Property Act, it mainly deals with the transfer of immovable property between two living persons. The living person must be in existence at the date of transfer. It is, I must say, it is a voluntary act of the party. That's why it excludes the transfer of property by operation of law, because will operates only after the death of the person. And it talks about the transfer inter vivos, transfer between two living persons. So, regarding sale, lease, because these are the transactions which are amounting to transfer of property. Lease, transfer, mortgage, sale, because there are certain transactions which does not amount to transfer of property under this act, like will is there, partition is there, because in partition the person, they generally obtain their own shares. Basically, there is no conveyance in that, there is no creation of new title or interest there. Compromise deed we have. In that also there is a compromise between the parties. So for that purpose we have this Transfer of Property Act, which governs the transfer of property. Next, the Indian Registration Act, as I had already discussed elaborately, that it mandates the registration of various documents related to land transactions, including sale deeds, lease and mortgages. According to Section 17, the registration is compulsory for the transfer of immovable property of the land of value of rupees above 100. There are many more legislation which plays a part in governing different facets relating to the land, such as Indian Stamp Act, Power of Attorney Act, Indian Contract Act, etc. Because Indian Stamp Act, it also plays an important role here. By this, the government, it receives taxes over the property, because with respect of immovable property, it must be registered, the person has to pay the stamp duty, otherwise the penalty will be imposed as per this act. So these are important provisions here which deals with this transfer of property. The evolution of land right laws is not an overnight process. Each legislation has its own extensive history and journey, shaped by cultural, historical and socio-economic factors over time. Because the historical background, as I had already discussed with you about the first legislation which was enacted by the Britishers, then the enactment of the British 1, British 20 Act of the land disputes, all are related to this one, and then it was basically by the repealed by the 2013 Act, which main purpose here is to provide fair compensation and greater transparency in the land acquisition process. So, after this session or after this lecture, you will be able to understand what is the difference between the land and the property, because I had explained that land is a subset of property. Property, as property may be movable, it may be immovable. So, there is a difference, both are related terms, but there is a difference between these two. Then I have given an overview of the land rights in India. Land rights like leasehold rights, freehold rights, I have discussed that it refers to the absolute interest, right or title in the concerned land. We have developmental rights, subsurface right. So, these are the various rights which are given to the person. Then I had talked about the historical development and this evolution of the land laws, how it was enacted, how the laws have evolved over the centuries to reflect the changing you can say that social, economic and political realities of the country. So, land basically plays an important role. Everyone wants to have a land. So it is not so that one person said that it is land. So if I here, because in this lecture I had discussed with you about the historical development. So the evolution of land rights is not an overnight process. That's why I have here given this statement that each legislation has its own extensive history and journey, which is shaped by cultural, historical, and socio-economic factors over a time. I'm talking about here the Transfer of Property Act 1882. Because earlier there was no such act for the transfer of immovable property. We have so many laws for the transfer of movable property. We have Indian Contract Act, we have Succession Act, Hindu Succession, we have a law of forfeiture. But for the transfer of immovable property, we do not have sufficient laws earlier, 1882. So for the first time in 1882, this Transfer of Property Act was enacted, because what happened, the judges give the decision as per their wisdom, as per their qualification. They give the decision on the basis of equity, justice and conscience. So only after the enactment of this act, there is the provision which governs the transfer of property, including land, through sale, gift, lease or mortgage. So there are now the provisions which govern these things in the Transfer of Property Act. We have so many provisions what kinds of property may be transferred as given in section 6, because it is only the property must be in existence at the date of transfer. This is very important, because here as the definition given in section 5, that the act of a person which conveys property in present or in future. So this word conveys, it basically governs here the rights, the in present or in future. It does not governs the word property. The property, it must be in existence. Spec succession is talking about here, spec succession, that where the expectation of succession is there, expectation of getting a property in future, then that transaction is void as per this act, because section 6 clause A clearly here provides that if there is a chance of an heir apparent, chance of a legacy, then those transactions are void as per section 6A. We have the provision of gift, because in gift also the acceptance by the donee is also essential. It is not only generally necessary that the donor must be competent. He must be competent, but the donee must also accept that gift. Even it is a gift, it is maybe burdensome gift. So the donee may not have accepted. So it is essential for the person to have accept that gift. Talking about here lease. Lease is a transfer of limited interest. Limited interest, because even then also it comes under the transfer of property, because the person gets the property under a lease even for a period of 6 months, even for a period of 2 months, but he gets an interest, the benefits which are rising out of land. So that's why it comes under the definition of transfer of property. Mortgage, equally, it is also a transfer of an interest in immovable property. It is basically as a security for the repayment of money made by the mortgager in favor of the mortgagee. I have talked about various kinds of mortgages, why registration is compulsory, because the person cannot go before the court if there is any dispute arises in future. And there are so many disputes with respect to the property, everyone, because nowadays there were many disputes with respect to the property. So one must know the provisions which are given here in Transfer of Property Act, which governs the transfer of property, including land through sale, gift, lease or mortgage. Talking about here Indian Registration Act 1908. It is equally important as like the Transfer of Property Act. Transfer of Property Act, it tells about the process, it gives the rights. It is basically a substantive law, because there it is given that for the transfer there are 3 essentials. First one is execution of the document, second is attestation, and third is registration. These are the essential elements of the transfer of property. So if one has done the execution as well as attestation, but the registration is not done by them, then but obvious they have to face the difficulty in future. So for that purpose, we have this Indian Registration Act. This act mandates the registration of various documents relating to the land transactions, including sale deeds, lease and mortgages, because by this only the person get the valuable evidence with respect to the transactions, with respect to the documents which has been executed by him. Only then it has some evidentiary value in the eyes of law once the sub-registrar has signed the document, has mentioned the date and time on the back of the document. So it is a document which is basically, I must say, it is used in the term which is used in the transfer of property for document is instrument. So then only the instrument have an evidentiary value in the eyes of law only after this passing of this Indian Registration Act. There are many more legislation which I have already discussed in brief about this Indian Stamp Act, Power of Attorney Act, Indian Contract Act 1872, because Indian Contract Act, it governs the general principles. It has a, like, if a person has made a breach of contract, one doesn't want the damage, then he has to go for the specific performance of the court. He has to file a case for that, that the court must compel the person to perform the contract, because he is not satisfying in getting the compensation, in getting the damages, in getting the quantum merit. So he has to follow that one. So for that purpose also, this Indian Contract Act, it also plays an important role in the transfer of property. So the evolution, I'm talking about here the evolution because this lecture is basically on historical development and evolution. So the evolution of this land laws, these land rights is not an overnight process. That's why I have here telling this thing repeatedly. Each legislation has its own extensive history and journey, which is shaped by cultural, historical and socio-economic factors over time, because the laws which have evolved over the, you can say that over the centuries to reflect the social, economic and political realities of the country. So for that purpose, we have the historical background, which is very complex and fascinating, as I had already made this statement before you. So this is what I have here explained in this session about the land laws, what the land law is. So I think the land laws, the land, what are the land rights, what laws are there to govern these land rights, what are the acts which basically deals with this land laws, like Rehabilitation Act 2013, which repealed the earlier Land Acquisition Act 1894. So I think now you must be able to understand the historical development, the evolution, the importance of land laws, the land rights and significance of ownership and how to access this land, because one must know how to access it, to know about their land rights, how to get the land from the person, right to land as a tenant, right to land as a lessee, as a tenant, as a licensee. So this land law is basically played an important role in every person's life. It is in the last, I must say that every man have a property in the eyes of law, and as per this one, as per this lecture which I have just delivered, you may be able to understand very clearly that these are very important for every person to know the what's its how they evolved and how they one person can get the right land rights, etc. Thank you.